Hi, I'm Ruth Colker. I'm a professor of law at the Moritz College of Law at The Ohio State University, with a chair in constitutional law, which obviously is where I have a lot of expertise.
Well, thank you for joining us. You wrote an article recently called The White Supremacist Constitution. And I would love for you to kind of just tell us what brought you to this topic and why you wrote the paper.
Well, I've been teaching constitutional law since 1985, which is a fair amount of time. And the course that I've been teaching has changed dramatically in terms of the precedent that I would teach the students. And so when I first began teaching, I think it'd be fair to say that I was largely teaching my students about cases that one might think of as assisting African Americans and women to better attain civil rights protection in our society. And then over time, increasingly, I noticed that instead of teaching cases that might be thought of as benefiting African Americans and women, I saw myself as teaching a lot of cases that benefited sort of white Christians. And we could talk about the religion theme also, which I'm currently writing about. And so it's been a big evolution. And I began to understand that today, it is fair to say that if I'm a member of the board of the American Civil Liberties Union, so that sort of puts me in a sharp category there. If you're a progressive lawyer, today you would probably see the courts as the forum of last resort, that you would use it to defend yourself from adverse state treatment, but you would be reluctant to use the courts as an affirmative tool. And that's a big change. And so in the article, I sort of sketch out how that change came to happen.
Yeah, and before we move forward, maybe you could kind of just outline for us what you mean by affirmative tool, because I think there were some places in the article where I think I know what you were saying, but as a layperson, I'm not positive that that's what you were saying.
Well, a case that a lot of people are familiar with is Roe versus Wade. So if you think of Roe versus Wade from 1973, so that's some time ago, the plaintiff in that case was not able to obtain an abortion in the state of Texas, and the Texas statute had virtually no exceptions and no exception that she would have qualified for. And so what did she end up doing? She ended up finding a lawyer who brought a case on her behalf and used the 14th Amendment of the Constitution as an affirmative tool to say that the 14th Amendment should be understood to protect the woman's right to decide whether to bear or beget children. And part of that decision-making process would be deciding whether to continue with a pregnancy. So that would be a case where the law would be used as an affirmative tool. It's a vehicle to assert rights claims. By contrast, today, those who are more likely to use the Constitution as an affirmative tool would be more likely to be, for example, white people who think that they have been victims of discrimination. In those cases, some of which the court, of course, is hearing this term in terms of affirmative action cases. In those cases, the argument that white people are making is that we should understand the Equal Protection Clause as protecting them from discrimination, including measures that we might think of as remedial tools to create more diversity in society. So in that case, people who are representing civil rights organizations would have to be defending against that claim, right? But they're not using the Constitution affirmatively to broaden courts' understanding of their rights.
Thank you. That was very helpful. I would like to kind of dive head on into the kind of the thesis of your article here, which is that I'm going to quote from one of the first opening paragraphs, which is that the Constitution can be used as a tool The U.S. Constitution can be used as a tool to invalidate democracy entrenching measures. And then goes on to say the U.S. has never been willing to allow democracy to flourish because democracy might be a challenge to some aspects of white supremacy. And we're in our current discussion talking about whether or not the Constitution was written pro-slavery or pro-freedom, like abolition. And I think that this strikes right to the heart of something that is kind of left out in that debate, which is white supremacy. And slavery was white supremacy, but white supremacy continues once slavery ended. And I think that the Constitution, as you argue in this article, really does support kind of what you were just talking about, white affirmative, kind of using the Constitution to reestablish white rights, as it were. So maybe you could kind of just walk us through your thinking on that.
Yeah, I mean, one might say it wasn't inevitable that the courts would conclude that the Equal Protection Clause protected white people in exactly the same way as it protected those who were formerly enslaved. Given that the 13th Amendment banned slavery, one could imagine in context when the 14th Amendment refers to the equal protection and rights of persons, that we would think of those persons as being those persons who were formerly enslaved or possibly formerly enslaved. And for some time, that is the way a majority of the court thought about what we call the Equal Protection Clause. But over time, and it's increased, the speed has grown rapidly in recent years, the courts have increasingly seen the Equal Protection Clause as every bit as much a protector of the rights, the so-called rights of white people, as the rights of African Americans. And I mean, that's obviously an important point, but there's an additional point I make in the article that I hope it isn't too much in the weeds, but it's an important point, which is that because of those rulings and other rulings, the courts have also concluded that Congress doesn't have the latitude that we once thought it had to enact civil rights laws. And so I think probably, your audience is aware of some of the changes in the voting rights laws that the courts have caused because they have struck down some aspects of the voting rights laws that Congress enacted. And so one of the stories I tell in the article is something that probably most people wouldn't be aware of, which is the big series of cases in which the Supreme Court hasn't just been willing to rule in favor of white people, mostly white men. It also has limited Congress's role to enact civil rights protection. And that has happened with respect to the Family Medical Leave Act, has happened with the Americans with Disabilities Act, a statute I've done a lot of work on, the Age Discrimination Employment Act, and the Voting Rights Act. So we're talking about women, Blacks, disabled people, and older people. That's sort of a pretty big constellation where the courts have said to Congress, nope, because we have interpreted the Constitution narrowly in terms of whose rights it protects. You, Congress, can't step in and try to enhance protections in those areas. And I think that story is one that a lot of people aren't aware of, because I do think that's more in the weeds story that people like me would be aware of.
Yeah, and I think, but that development, I think, you would agree from the article, is kind of baked into the Constitution, correct? I mean, maybe not the court's limitation of Congress, but the court's protection and extension of kind of segregationist and slavery modes of thinking, which would be, white supremacist or, leading to. So I guess my question is, how has the Constitution kind of used the court to invalidate the democracy? And I think you were just speaking about it, but maybe you could kind of give us more of a.
Yeah, again, some aspects are inevitable, some aspects aren't. So some of the inevitable aspects is that, the District of Columbia doesn't have any representation in the United States Congress. They don't have their 2 senators. They have as much population as many other states, but don't have 2 senators. I think we all know that the population of the District of Columbia is overwhelmingly Black, right? And so, of course, maybe that didn't happen at the founding, because of the founding, Black people couldn't vote, essentially. But, over time, that's become clear. And, Congress has vehicles it could take to remedy that problem, and it hasn't. The Constitution was enacted to give, 2 Senate seats to every state, irrespective of population, and the smaller population states then and now, often, then especially we're in the South. And when you couple that with the 3/5 rule, which allowed them to, during slavery, to count 3/5 of a Black person as part of their population, even though those people couldn't vote at all, that was a step put in the Constitution to promote white supremacy, right? To promote the rights of the Southern states that were still enslaving people. So there the Electoral College is anti-democratic. The way we count how much states get, and so obviously California and New York, which are heavily Democratic and have large minority populations, get very, compared to their population, they get very little influence over in the Electoral College. So there are some mechanisms that are built in, right, that we would have to amend the Constitution to get rid of it. Amending the Constitution itself is obviously a very difficult thing to do. There are other parts of it that you might say it wasn't inevitable that it would become a tool of white supremacy. The one that I was discussing before is that when Congress enacted the 14th Amendment, which is one of the post-Civil War amendments that provides equal protection rights as well as other rights, it put in Section 5, which says that Congress may make laws to enforce this article, the 14th Amendment. And so I've written a lot about Section 5 from an historical perspective and a doctrinal perspective. But the important point is that when the 14th Amendment was ratified, they gave Congress the power to draft legislation to enforce it. And one would think that that enforcement would expand the reach in scope of the 14th Amendment. Like, why else give Congress that power? And that is how we understood Section 5 of the 14th Amendment for many, many years, until the 1990s. And so mid-1990s. And so I don't think that's inevitable. I think the courts could go back to their earlier understanding of that and return to Congress a lot of power to enact civil rights laws. As an important example, a lot of people are upset with the court's decision in Dobbs, the abortion case. And some people, principally Democrats, have said, Congress should get in the game and it should have passed a nationwide law, to support abortion rights. Although politically I would favor that, the courts would strike it down in about 30 seconds because they would say it exceeds Congress's Section 5 powers in light of the Dobbs decision. And so people should understand that, which I don't consider inevitable, that language in the Constitution has been used in ways that have undermined the ability of Congress to enact broad civil rights protections. And that's some very serious damage and limitations of Congress's powers.
Yeah, I think the way you talk about it in the article is that the courts protect Congress's legislative power, but restrict its power to overthrow court decisions. So if there's like you were just saying, there's this court decision now about abortion, and if the Congress tried to do something about it, would be thrown out. Is that correct in what you were? I think.
Yeah, I mean, it is well accepted that the Congress. This goes back to Marbury versus Madison. It's well accepted that Congress doesn't have the power to amend the Constitution. We have a process for that, right? And so if you think there's something in the Constitution that's wrong, you need to do something about it through the amendment process. And so the question is, what can Congress do short of literally amending the Constitution, literally overturning a Supreme Court decision on its face? And so there could be ways that Congress, going back to the voting rights area. In the voting rights area, we had a long series of cases in the 80s and the 90s in which the court was willing to allow Congress to do a lot to protect voting rights. And in those cases, the courts said it's okay for Congress. It was called a one-way ratchet theory. It's all right for Congress to expand. It just Congress can't contract. And so if that's your view of Congress's power under what I called previously Section 5 of the 14th Amendment, then you would say, okay, it's all right for Congress to add more protections to women who find themselves pregnant. It just can't do less than the Supreme Court has said is mandated. In the abortion area, that'd be pretty easy. The court says nothing's mandated, right? But that wouldn't necessarily preclude Congress from deciding itself that it wants to add protections. So that's what I used to teach as the Supreme Court's doctrine, because that was the doctrine, and that no longer is the doctrine. We no longer have what we call the one-way ratchet theory. But that would be beneficial if we went back to the one-way ratchet theory. It would give Congress much more power to add protections in the area of civil rights.
So I guess leaving my notes, but just, from what you just said, what do we have now if it's not that one-way
ratchet?
Yeah.
Well, the courts have said that basically Congress can just put into legislative form by statute those rules that the court has created through constitutional law. So the courts do consider some measures to violate people's voting rights, right? you can't prohibit voting right on the basis of someone's race. You can't, and there's things that you can't do. And so Congress is certainly entitled to put into legislative form, you can't do those things. And if you do those things, here's the remedy that you get, right? Because the Constitution doesn't specify a remedy. That's easy. Every member of the court agrees Congress can do that. The question is, how much more can Congress do? So there was a case many years ago where Congress upheld a literacy requirement for voting in one municipality. Nonetheless, the Voting Rights Act bans literacy tests. So is that good constitutional law or not? I mean, will the courts eventually rethink that and say, yeah, those literacy tests, they're fine. Congress can't ban them because we said in this one case that a literacy test wasn't unconstitutional. Those are the kind of questions we'll face in the future.
And how much of this dynamic is based in kind of a federalist versus statist kind of tension?
Well, I think the people who support these theories would say primarily that they are originalists, that they're trying to go back to the original understanding of the Constitution. It's these days is a little bit harder to use the states' rights versus federal rights dynamic to explain the court's reasoning, because these days we see the courts in the affirmative action area as overturning state laws. But we also see the courts overturning Congress's powers. So we see the court do things negatively to both states and Congress. Maybe it's even-handed in that way. But I'm sure, as we all know, the majority of the court these days would justify their decisions on originalist grounds. And the problem with that framework, of course, is that when the original Constitution was drafted, African Americans, women, weren't voting. Oftentimes there was some property rights, so it was more upper class people who were voting. And then we amended the Constitution, after the Civil War. And so it seems to me one problem with the way originalism is espoused is they don't bother to think, well, how do we have to re-understand some of these earlier rules and policies in light of the 13th and 14th and 15th Amendments, which of course are very important. And then when they do discuss the 13th, 14th, and 15th Amendments, they actually do so from a very ahistorical lens. And so if you follow the affirmative action discussion at the court, there was some discussion by the more liberal wing of the court, like, hey, what happened to your originalist lens? You're not looking at the history of the 14th Amendment. So it's an interesting deploy of history when it's useful to the political results that one might say that they want to attain.
Yeah, and I just barely I followed the Second Amendment decision that came out, I think last summer, well, whenever it came out recently. And that originalist reading was just so, to a layperson, sounded so preposterous, but at the same time, it just expanded this, Yeah,
I mean, the Second Amendment is obviously a hugely important area. I don't do this anymore in part because the Second Amendment cases are so hard to understand, but I used to have my students just read some of the Second Amendment opinions to see the different tools of analysis that different members of the court use. But the problem in the Second Amendment area is that the history is so fraught. I mean, the historians won't agree among themselves about the history. And I guess that's not surprising. History is an objective science. And so that's another problem with originalism, that it sort of pretends we can get more out of the history than we should. But again, with respect to the Second Amendment, how do we re-understand the Second Amendment in light of what has happened since the Constitution was ratified? Those are important questions. And obviously, when they enacted the 14th Amendment, they ratified the 14th Amendment. We didn't have AR-15s and all that stuff, So it's that the willingness to think about contemporary circumstances is something that originalism is cautious, hesitant to do.
Well, I think we should move briefly into the Equal Protection Clause and kind of how that functions as a support of this kind of white supremacist constitutionalism. And also, I guess it's the Bakke case or the Bakke case?
Bakke.
Yeah. So maybe if we could use that to kind of unpack equal protection and how it's factored into the story.
Yeah, the Bakke case is important, right? It's a case involving a white man who wanted to go to medical school. He was an older applicant and didn't necessarily have the same profile as some of the younger applicants, and he wasn't able, as far as I know, to get into any medical school. But I think it was UC Davis that he was trying to be admitted to, and so he made the argument that there were seats that were set aside for racial minorities that he couldn't compete for, and that itself was an equal protection violation. And so in a closely divided case, the court ruled for him, but said in various parts of the decision, we're not saying that there can't be any affirmative treatment, and they complimented Harvard, where I happened to go to college and law school, for the way they sought a diverse class and the way they used race as supposedly a plus factor rather than a sort of quota, set aside quota. And so following Bakke, I don't think people thought affirmative action was dead, but people thought that they would now have to use it in a more subtle way and read the file as a whole instead of having, different slots that people fit into. But over time, the Bakke decision is no longer good law. Over time, the court has narrowed the way you can even use race as a plus factor. And this term, I think we all expect the court's going to bar any use of race as any kind of consideration during admissions, which will be very challenging. So maybe if I'm an African American, maybe I wouldn't check off a box, I'm an African American. But then in my essay, of course, I might start with the first sentence to say, I'm an African American who's faced racism in my life, and go on to describe it. And then what's the admission committee supposed to do? Disregard that person's statement and the oral arguments. The court says, no, it's okay to consider the essay, but you can't check the box. So, we're humans, right? When we read these essays, I don't know what this is going to mean. And for really large universities like the University of Texas or Ohio State University, where I teach, there are a large volume of files. It's a little easier at law school where we admit so few students, but I don't know what the large state universities will do after the court strikes on affirmative action. It's certainly going to make their jobs. I guess they're going to hire a lot more admissions officers.
Right, and job creation, I suppose. But I guess what I'm fascinated by is how you take something that is geared toward equalizing the playing field, bringing someone up to, so the African American is supposed to be they're supposed to be helped by affirmative action. But here we have white people turning it around and saying, I'm now the product of discrimination, when, that's not, on the face of it, it seems like it's not, it's an absurd argument.
Well, there's been this rise of white people describing themselves as victims, right? We've seen this. And that argument has received a lot of credence in a lot of corners. Politically, obviously, a lot of people in this country who support that kind of argument. And so, if I think of the purpose of the 13th and 14th and 15th Amendments as helping our country overcome the horrible experience of slavery and understanding I can't really understand it, right? But what it would mean, right, to come to the United States forcibly on slave ships and have your families torn apart, that you can't live with your children and you can't marry and you can't get an education. And if you're a woman, you'll be likely forcibly impregnated by this white boss, could be Thomas Jefferson, of course. And so to think about the 14th Amendment as, flowing from that history would, and the Congress that had ratified the 14th Amendment did pass civil rights laws that it understood to be remedial in that sense. But in, I think, a very ahistorical move, the current court has said, no, race discrimination is race discrimination. It really doesn't matter, who's being victimized. And also it doesn't matter what the purpose or goal is. It doesn't matter if it's a so-called remedial purpose or goal. That isn't permissible. It doesn't get any extra weight because of that. So it's to the extent that, we think we should be a diverse society, in where I am in a university setting, it's definitely going to make it harder to use those tools.
Yeah, and yeah, that's all I can say is yeah. So I guess the kind of wrapping up our discussion is, in the article, you do talk about abolition and kind of how the court and, well, not so much the court, but how the Constitution could be used and what we could do to kind of abolish white supremacy from this system and kind of not purge it, but in some regard correct for it. And what do you mean by abolition, and how would that manifest?
Well, I don't actually think the Constitution would be an important tool in that evolution. So when I think about the abolition movement, I think of, a lot of the work that Black Lives Matter movement has done. And so I think that if we want policing to change, right, at the local government level, if we want the police to not be called in to mental health crises, and we've seen, terrible results when that happens, if we instead want those responses to be by social workers and people trained to help people who are having mental health crises, that is going to be something we have to do with the grassroots level. And I think the Black Lives Matter movement has done a great job in making people aware of the ways in which local policies can have really degrading effects on people's lives. And so I actually don't see the Constitution as an important tool in the abolitionist movement. Others disagree with me. Dorothy Roberts, who's a professor at Penn, who I greatly admire, she thinks otherwise. She thinks the Constitution can be a tool of abolitionism. You have to get her on your show to have her defend her own views. But I think, at least at this time in our nation's history, that's a hard argument to make, and it's not a primary argument I'm trying to make in the article. I think that it's helpful for us to understand which tools are no longer on the table to help achieve progressive aims, so that we can think about other tools that can help us see progressive aims. And as I said, grassroots local work, I think, is probably the primary tool to be used.
That's great. And I probably misspoke in the question, but thank you for correcting me, because I did, I know that you're kind of saying the opposite of what I was asserting. So I guess what I would love to know is where you think we go from here, and what can the grassroots is one, but how some of the stuff that would be enacted in the grassroots would then be challenged in the courts going up. And what is our outlook at this point? What's the prognosis?
Yeah, right. So you're right that at the grassroots level, we can't do everything that we might want. And one example I give in the paper is that when Biden was first inaugurated as president, one of the things he said is he wanted to channel some COVID money, especially to minority communities that were especially hit by COVID. And there was huge backlash. That's going to be unconstitutional. And they ended up understood that the courts would likely say they couldn't do that. I mean, and so then you have to come up with some other way, low income communities and urban settings, and then, you can channel the money that way. You have to find another way to say it. And so, obviously, when people are giving advice to local government leaders, or in the case of the President of the United States, you'd have to be aware of those limitations and try to find ways to work around them. The other thing is, of course, who's on the Supreme Court is really important. And the Republican Party made a big deal out of trying to make sure that people who were aligned with their point of view were on the Supreme Court. They've obviously been hugely successful at that in recent years. We have no idea whether there'll be any further openings during the Biden administration. Of course, we don't know who's going to be the next president, for that matter, either. But I think that people maybe now, when they go to the polls, are more aware of how their vote for the U.S. Senate and the presidency have major implications for who's on the court. But that's a slow path, right? I mean, because there are no term limits on the Supreme Court. And just as some senators try to hang on when they're 89, there are some members of the Supreme Court who hang on even when their health is failing. So, but I think people's eyes are, if they weren't open before, I think they're open now to the fact that it actually matters who's on the Supreme Court.
Well, and I think my last question, as you were talking, I just thought of it, because you did open the door with the white Christian nationalists. Do you think that and this is just your personal opinion, the court as we see it is the product of a white supremacist movement? in that like some of the group that kind of gave Trump the list of judges, we saw it in the federal, we see it at the Supreme Court level, were very conservative, very right-wing, and very kind of evangelical nationalists. Is that a fair statement, do you think, to say that this has been a rising again of a white supremacist movement in the country?
I mean, obviously it's had that consequence. I'm a little hesitant to say from an intent perspective that was, their intent when they were changing the people on their list. I think they were definitely trying to find people who had an originalist methodology, were willing to overturn Roe versus Wade. I mean, I think those were the two big litmus tests. And it may be that people who fall into that camp also tend to hold, some other views that support what we might call Christian nationalism. So I guess that's how I see it, but I'll have to think about that more. I hadn't really thought about the process so much. That was a good question.
I just thought of it while you're talking, so it was just off the top. So thank you for this. And if people want to read more of your work or, possibly get in touch, how would we contact you?
If you go to Ohio State University Moores College of Law, you can find me on the directory, and I have an email there and a website and all sorts of things that people could find. So thanks so much for your time. I really appreciate it. And it sounds like you have some great people who are interested in learning more, and I'm happy to help with that conversation.